Okay, so today the chapter we're gonna cover is trespass to the person. Okay, the first topic we're gonna cover is battery. Second is assault. Third one is false imprisonment. Fourth is total restraint. Fifth is unlawful detention. Let's talk about lawful detention. In the end, we'll talk about remedies, which are A part, action for damages, B part, self-help, and C part, habeas corpus. Fine. So firstly we'll talk about battery. So what is battery? Intentional use of force without lawful justification. बस यही है बैटरी. ठीक है, इसमें इसके दो एसेंशियल्स इसकी डेफिनेशन में देख रहे हैं, which are number 1, use of force. Number 2, without a lawful justification. ठीक है. So firstly we'll talk about the first essential, which is use of force. ठीक है. So बैटरी की डेफिनेशन में यूज ऑफ फोर्स का मतलब ये नहीं है कि यू हैव टू पंच समवन, यू हैव टू पुश समवन, ये किसी को मार ही देना है. दैट इज नॉट बैटरी. इवन स्लाइटेस्ट टच कैन रिजल्ट इन बैटरी. एज वी कैन से दैट फिजिकल हर्ट इसकी डेफिनेशन में कहीं भी मेंशन नहीं किया है. सो फिजिकल हर्ट इसकी डेफिनेशन का पार्ट नहीं है, तो बैटरी में फिजिकल हर्ट होना जरूरी नहीं है. इवन स्लाइटेस्ट टच कैन रिजल्ट इन बैटरी. मोरओवर यू डोंट इवन नीड टू टच समवन फिजिकली. यूज ऑफ स्टिक्स, बुलेट्स, प्रोजेक्टाइल्स, डिफरेंट चीजें जो किसी के ऊपर फेंक सकते हैं, स्टोन्स हो गए, कुछ भी हो गया, एंड इवन थ्रोइंग ऑफ वाटर can amount to battery. Okay, so next thing, इसमें एक और चीज आ जाती है जो एक मेजर चीज है, which is passive obstruction. Now they say that अगर बस मैं रास्ते में खड़ा हूं और कोई आके मुझसे टकरा रहा है, ओके, तो क्या वो भी बैटरी में अमाउंट हो जाएगा? इसमें एक केस था इंस वर्सेस वाइली. इंग्लैंड का केस है. इसमें क्या हुआ था? वाइली वॉज अ पुलिसमैन एंड इंस द प्लेंटिफ, ही वॉज ट्राइंग टू एंटर अ क्लब. But he was stopped by Wiley. And stopped in what way? That Wiley was just standing there as a passive obstruction and did not let ins pass. So Ince brought a suit of battery against him. It was held that Wiley did not use any force against him. He was just a mere passive obstruction in the way, and hence that Wiley was not liable for battery to Ince. Okay. So if the person is standing just like a mere obstruction, it will not amount to battery. The second part of battery is without lawful justification. इसमें Justice Holt, he was a great jurist and a very learned judge. He had given a lot of remarkable judgments and a lot of definitions too. So, Justice Holt said that in a narrow passageway, while walking, we accidentally at times brush our shoulders or brush our arms against each other. That cannot be called battery. But if a person is forcing his way, pushing people, clinging them with walls, just making his way, hurting others, then it will amount to battery. As the force used here is not justified. But there is some lawfully justified force too. Justified force. Lawfully justified force. For example, एक केस हुआ था प्रताप दाजी versus BB and Central Railways. इस केस में क्या हुआ था? प्रताप दाजी was traveling in a train without a ticket. So he got off on an intermediate station. To purchase a ticket. But he could not get it. On the next station, when the TT asked him for the ticket, he could not produce it. So he was asked to get off. But Pratap Daji refused to get off the train, which caused use of forceful ways to get him off the train. So Pratap Daji brought an action against PB and Central Railways, stating that it was a case of battery and he was unlawfully thrown out of the train. But the court held that as he did not have a ticket, he was a mere trespasser on the train, and the force used could be totally justified. So as the force use was totally justified, he did not get any compensation. Fine. That was for battery. Now moving on to assault. Assault is an important topic again. Assault has been discussed in criminal law as well as in law of torts. So in law of torts, assault is an act of defendant. Obviously, because plaintiff will be the one who will be affected. Which caused a plaintiff a reasonable apprehension an act of defendant caused a plaintiff a reasonable apprehension of infliction of battery on him. Fine. An act of defendant which causes or caused a plaintiff a reasonable apprehension of infliction of battery on him. Now, इसको और सिंपल लैंग्वेज में देखते हैं. Let's take examples. Pointing a gun is assault. Pointing a gun at someone. A points a gun at B. It's an assault. Waving a stick is again an assault. Fine. But shooting a gun and shooting a person will lead to battery. In the same way, waving a stick is assault, but as soon as it hits a person, it becomes battery. Let's take another example. Let's take a case law, which was Stephen versus Meyer. It's a case of England again. So what happened? There was a meeting. Stephen was the chairman and Meyer was a member of the meeting. They were seated in such a way that Stephen and Meyer had around 6 to 7 people in between them. Fine. So, in the due course of meeting, it was decided that Meyer was to be thrown out of the committee. So, which angered Meyer, and Meyer got up from his seat with clenched fists. Threatening to punch Stephen. And saying that I would rather throw the chairman out now. He was stopped by the people in between, and Stephen brought a case against Meyer for assault, and it was held that yes, it was an assault. And Meyer was liable to pay compensations to Stephen. The other rule which we're gonna talk about is that assault precedes battery. जैसे कि ये है कि बैटरी से पहले असॉल्ट होता है. फॉर एग्जाम्पल क्लेंच्ड फिस्ट असॉल्ट, actually punching, battery, throwing water, assault. As soon as the water falls on the person, battery. So generally assault precedes battery, but not in all cases. It's just a general thing. For example, if a person is attacked from behind, there is no apprehension of attack, hence no assault, but battery is there. Fine. So this was all about assault. Moving on further, now we'll talk about false imprisonment. Now, what is false imprisonment? False imprisonment is imposition of total restriction for a period of time, no matter how short. Total restriction upon the liberty, which is a basic right, fundamental right, right to liberty, of other without lawful justification. Now, false imprisonment is imposition of total restriction for a period of time, no matter how short. ठीक है, टोटल रिस्ट्रिक्शन किसी को रोक के रखना एक स्पेसिफिक टाइम पीरियड के लिए, लेंथ डजंट मैटर, जितना चाहे बिल्कुल छोटा हो या बहुत लंबा हो, अपॉन द लिबर्टी ऑफ अदर विदाउट लॉफुल जस्टिफिकेशन. सी, अगर जस्टिफिकेशन लॉफुल होगी, सो इट इज नॉट अ टॉर्ट, इट इज नाइदर अ टॉर्ट नॉर अ क्राइम, देन इट वुड नॉट अमाउंट फॉर false imprisonment. But if it is unlawful, then it is false imprisonment. Moreover, अब इसके एक बार essentials देख लेते हैं. Essentials can be seen in definition itself. First one and second. ये तो हर बार ही होता है, because यहाँ पे lawful justification नहीं है, वो already एक essentials का बन जाता है. तो इसके essentials हैं. Number 1, total restraint. नंबर 2 है विदाउट लॉफुल जस्टिफिकेशन. फाइन. नाउ लेट्स टॉक अबाउट टोटल रिस्ट्रेंट फर्स्ट. अंडर क्रिमिनल लॉ, both total and partial restraints are punishable under section 340 of IPC and section 339 of IPC. But under law of torts, only total restriction is recognized. Fine. Only total restriction is recognized. अब इसका क्या मतलब हुआ? Let's take an example. इसमें भी एक example लेते हैं पहले. We'll go for, there was a case Bird versus Jones. इस केस में क्या हुआ? जोन्स था, जोन्स ने एक पब्लिक पाथवे पे चेयर्स लगवा रखी थी. ठीक है, there was some function whatever, तो उसने वहां पे उसके लिए चेयर्स लगवा रखी थी. Bird was walking on this pathway and he wanted to get on the other side. Mind you, there were other ways to go. There was a parallel pathway and there was a bridge also to get to the other side, but he wanted to go from this place. He went there, he tried to cross the chairs, but he was stopped. Then he waited there for half an hour. But still he was not allowed to go. Then he tried to force his way out by climbing over the chairs. He was pushed back and he was not allowed to pass. So Bird brought an action against Jones in the court for unlawful restraint. He said that he was restrained there for more than half an hour by Jones. Here, the court held that this was not unlawful restraint or false imprisonment. Accum. The court gave reasons that fine, if there was a blockade on the road, he had other ways to go, but he did not go. That it was a case of partial restraint. He was not allowed to go only in a particular direction. But all other directions were open to him to go, and as earlier stated that there was a parallel pathway and a bridge. But Bird did not choose to use those ways, so it was his fault and not of Jones. Moreover, for false imprisonment, a false imprisonment के लिए ये ज़रूरी नहीं है कि it should be inside a room, it should be like those rooms shown in movies or by kidnappers, etc. False imprisonment can be on a street, okay, a common prison, or your own room. Moreover, use of force is not necessary. Use of force is not necessary at all. But threat to use force is enough. अब टोटल रिस्ट्रेंट में थोड़ी सी चीज़ें आ जाती हैं, जैसे कि फर्स्ट इज मीन्स ऑफ एस्केप. As in Bird versus Jones, he had means to escape. He could have used the bridge, he could have used the parallel pathway, but he did not. If there are means of escape, it is not at all a total restriction and a false imprisonment. But those means should also be reasonable. Now, for example, in a room there is an open window but at a height of 10 feet and the room is empty. So there is no possible way a man can reach 10 feet to climb out of that window. Moreover, in an open street, if a person is told if he exits that street, he will be shot. So there is a fear and there is a threat to life and threat to use force. So such means of escape are of no significance and will still amount to false imprisonment. Fine. Now the second thing we're gonna talk about is knowledge of plaintiff. So the main question which arises here is that whether the plaintiff had the knowledge or not that he is being held unlawfully and without his consent. So there have been conflicting views on whether plaintiff's knowledge is important or not. There was a case, Herring versus Boyle, केस पे इंग्लैंड का था. In this case, it was held that it is important that the person should know about his false imprisonment. That he should know that he is being held under a total restraint. Okay. But this decision was criticized widely. By jurists all around the world. In another case, Meering versus Graham White Aviation Company. It was held that it was not important for the person to know that he is being held back falsely. This view was supported all over the world, and this judgment is mostly followed. Okay, means of escape. Then we're gonna talk about unlawful detention. Unlawfully detained. In order to prove false imprisonment, unlawful detention is very important. Fine. So, if a person, for example, take an example है basic. If a person is not released from jail, even after his acquittal, the court acquitted him of his crimes, but is still being held at jail. This is an unlawful detention. And this happened in a case which was Rudal Shah versus State of Bihar. Even if the court had acquitted him, he was still being held at the jail by the police. Fine. There was another case which is a very famous case, landmark case. Bhim Singh versus State of Jammu and Kashmir. Okay, so facts of this case. What happened? Bhim Singh was an MLA and he was going to attend an assembly session. But he was wrongfully detained from attending that. Okay, wrongfully. मतलब जैसे भी था जो भी था उसको अटेंड नहीं करने दिया. He went to the court against the authorities and it was held that it was an unlawful detention and he was also awarded a compensation of rupees 50,000 as an compensation. But if the detention is lawful, which is the next part, lawful detention. false imprisonment cannot be attracted and proved by this. When there is some justification, this is the word justification. When there is some justification for detaining a person, there is no false imprisonment. Justification for detaining. There's a case, John Lewis and Company versus Timms. Now what happened in this case? इसमें क्या हुआ था? Basically जो plaintiff था, plaintiff went with her daughter for shopping. So during shopping, the daughter stole four calendars and put it in her mother's bag. They were caught and they were detained in store. Okay, detained in the store till the manager decided whether to hand them to police or let them go. So the manager finally decided to hand them over to the police. So plaintiff brought an action against the store, against the manager of the store, that she was wrongfully detained until she was handed over to police. In this case, it was held that the detention was rightful as they were also held liable for the theft. Okay, so this was all about the offenses. Now let's talk about remedies. What can the plaintiff get if he's tortured, we can say, under these thoughts? Okay, so talking about remedies now. What powers does a plaintiff have? First one is action for damages. It's a very good remedy actually. Whenever the plaintiff has been wrongfully detained, this is the word again and again, wrongfully detained, he can always bring an action to claim compensation. Okay, damages in common language is compensation. And compensation can be claimed on what grounds? Grounds for compensation. They can be claimed for injury to liberty, number 2, also be claimed for disgrace, indignity, mental suffering, or they can be also for the wastage of time, etc. and etc. This is a very effective damage, and court can award a lot of compensation depending upon the harm occurred. Second one is self-help. It is similar to right to private defense. This remedy can be exercised when the person is still under detention. It gives the person power to use, again that word, reasonable force. We all know what is reasonable force, जितना जरूरी है उस चीज के लिए, not extra force, reasonable force to escape from detention. For example, अगर एक person को एक कमरे में बंद किया है, so if he breaks the window to get out, it's fine. But if he puts the whole place on fire, then it is not reasonable force, and it cannot be claimed under self-help. Fine. The third one, and the most important one, the one which has also been included in the Constitution of India, is habeas corpus. It is a speedier remedy. Fine. It literally means you may have the body. It is a writ. Okay, it is a writ petition. Writ which can be filed in Supreme Court under the Article 32 in Supreme Court and under the Article 226 and in the High Courts of the Constitution of India. Fine. Under this, a person detaining is ordered by court to produce detained person before court. And justify the detention. If the court finds out that the detention is unlawful, then the person is set free immediately, and the other person can be punished accordingly. The court may also grant ancillary compensation to the victim, as happened in Bhim Singh versus State of J&K, sorry. Fine. So that was for the remedies and trespass to the person. Thank you.